The United States just made a historic decision that could change everything for millions of green card holders across the country. If you or someone you know holds a green card, the next few minutes could be the most important information you hear all week. What was announced today has legal experts, immigration attorneys, and families scrambling to understand what this means for their future in America. Stay with me because by the end of this video, you'll know exactly how this affects you, what actions you need to take, and the deadlines you absolutely cannot miss. Welcome back to U.S. Immigration Alert, your trusted source for the latest immigration news and updates that matter to you. I'm here to break down complex immigration policies into clear, actionable information that you can actually use. If this is your first time here, make sure to hit that subscribe button and turn on notifications, because immigration laws are changing faster than ever, and you need to stay informed to protect your status and your future in the United States today. We're diving deep into the brand new immigration law that just passed, and trust me, this is something every green card holder needs to understand immediately. So what exactly happened today? The new immigration legislation that just passed through Congress and was signed into law represents one of the most significant changes to the U.S. immigration system in over a decade. This isn't just another minor policy adjustment or procedural update. We're talking about fundamental changes that will impact how green card holders maintain their status, travel internationally, renew their cards, and eventually apply for citizenship. The law was passed with bipartisan support, which tells you just how important lawmakers on both sides of the aisle considered these changes to be. The primary goal of this legislation is to modernize the immigration system, close existing loopholes, strengthen security measures, and create clearer pathways for lawful, permanent residents to achieve their American dream. Let's start with the most immediate change that affects every green card holder starting today. The physical green card renewal process has been completely overhauled. Previously, green card holders had to renew their cards every 10 years, and the process was relatively straightforward. Though often slow under the new law, the renewal cycle remains at 10 years, but now there are mandatory biometric updates required every 5 years. This means that even if your card doesn't expire for another 8 years, you'll need to appear at a USCIS application support center within the next 5 years to update your fingerprints, photograph, and signature. The government is implementing this change to enhance security and reduce fraud. Now here's what you need to know about compliance. USCIS will be sending notices to green card holders in phases over the next 18 months. When you receive your notice, you'll have 90 days to schedule and complete your biometric appointment. Missing this deadline could result in your green card being flagged as non-compliant, which won't revoke your status immediately, but could create serious complications when you travel, apply for jobs, or seek citizenship. The second major change involves international travel, and this is where many green card holders are going to need to pay very close attention. Under previous regulations, green card holders could generally travel outside the United States for up to 6 months without risking their permanent resident status, and trips under 1 year were usually acceptable. With proper documentation showing you didn't abandon your U.S. residence, the new law tightens these rules significantly. Green card holders will now be required to file a travel notification form with USCIS for any international trip expected to last longer than 60 days. This isn't asking for permission to travel, but it is a mandatory reporting requirement. The form is filed electronically and must be submitted at least 2 weeks before your departure. The purpose is to help USCIS track residence patterns and ensure that green card holders are truly maintaining the United States as their primary home. Additionally, if you're planning to be outside the United States for more than 90 days, you'll now need to provide documentation of your continuing ties to America. This could include evidence of U.S. employment that requires international work, property ownership, family connections, or other substantial ties that demonstrate you haven't abandoned your permanent residence. The consequences of non-compliance here are serious. If you return from an international trip lasting more than 60 days without having filed the travel notification, you could face enhanced screening at the port of entry, and repeated violations could lead to your green card status being questioned or even revoked for green card holders who travel frequently for work or family reasons. This means you need to establish a system right now to track your travel and ensure you're filing the required notifications. Now let's talk about one of the most controversial aspects of this new law, the public benefits reporting requirement. This has been a hotly debated topic in immigration circles for years. and the new legislation finally establishes clear rules. Green card holders who receive certain types of public benefits will now have that information shared between benefit-granting agencies and USCIS. This doesn't mean you can't use public benefits if you're eligible, but it does mean USCIS will have visibility into your benefit usage, and this information may be considered in future immigration decisions, particularly when you apply for citizenship or if you're renewing your green card. The specific benefits that trigger reporting include cash assistance programs, long-term institutionalized care at government expense, and supplemental security income, emergency medical care disaster relief. Public education and child nutrition programs are specifically excluded from reporting requirements. Here's what this means in practical terms. If you're a green card holder who falls on hard times and needs temporary assistance, you can still access benefits you're legally entitled to. However, you should be aware that this usage will become part of your immigration record. Immigration attorneys are advising that green card holders carefully document the circumstances that lead to benefit usage, maintain records showing it was temporary, and be prepared to explain these circumstances in future immigration applications. The law specifically states that benefit usage alone cannot be the sole reason for denying citizenship or green card renewal, but it can be a factor considered, along with other elements of your case. The new law also introduces significant changes to the naturalization process, which is obviously important for green card holders who want to become U.S. citizens. The basic eligibility requirements remain the same. You still need 5 years of permanent residence, or 3 years if you're married to a U.S. citizen. You still need to demonstrate good moral character, pass the civics and English tests, and meet the physical presence and continuous residence requirements. What's changed is the documentation burden and the interview process. Under the new law naturalization, applicants will need to provide much more comprehensive documentation of their entire period as a green card holder. This includes tax returns for all years of permanent residence, travel records, employment history, and residential addresses. USCIS is also implementing expanded background checks that will look more thoroughly at financial records, social media presence, and public records. The naturalization interview itself has been extended. Previously, interviews typically lasted 20 to 40 minutes. Under the new procedures, applicants should expect interviews lasting 60 to 90 minutes, with more detailed questioning about their application, their time in the United States, and their understanding of U.S. civic values and government. This isn't meant to make citizenship impossible, but rather to ensure that those who become citizens have truly integrated into American society and understand the responsibilities of citizenship. For green card holders planning to apply for naturalization, the message is clear. Start organizing your documentation now. Keep meticulous records of everything: travel logs, tax returns, employment letters, lease agreements, and any other documents that prove your physical presence and ties to the United States. Let's discuss employment changes, because this affects millions of green card holders who are working in the United States. The new law doesn't change your fundamental right to work anywhere in the country, but it does introduce new employer verification requirements that you need to be aware of. Employers will now be required to re-verify employment authorization for green card holders every 5 years, aligned with the new biometric update schedule. This means your employer will ask you to present your green card and complete a new I-9 form every 5 years. This is purely administrative, and as long as your green card is valid and you've kept up with your biometric updates, this should be a simple process. However, if you've let your biometric updates lapse, you could face employment verification problems, even though your green card itself hasn't expired yet. For green card holders in specialized fields, particularly those who originally came to the United States on employment-based visas, there's another important change. The new law creates a fast-track citizenship option for individuals working in critical shortage occupations, including healthcare, advanced technology, scientific research, and education if you've maintained continuous employment in one of these designated fields. For at least 3 years as a green card holder, you may be eligible to apply for citizenship after just 3 years of permanent residence. Instead of 5, this is a significant benefit, designed to retain talent in crucial industries. USCIS will be publishing the official list of qualifying occupations within the next 60 days, so if you work in one of these fields, keep an eye out for that announcement. Family immigration has also been affected by this new law, particularly for green card holders who want to petition for family members to join them in the United States. Green card holders have always been able to petition for spouses and unmarried children, but the processing times have been notoriously long, often taking years. The new law doesn't magically speed up these timelines, but it does introduce some protections. If you filed a family petition and you're waiting in the queue, your family members will now be eligible for temporary work authorization after 12 months of waiting, provided they're already in the United States in another legal status. This doesn't speed up their green card approval, but it does allow them to work legally while they wait, which is a significant quality of life improvement for many families. There's also a new provision that protects the derivative status of children who are waiting for green cards through their parents' petitions. Under previous law, children who aged out, meaning they turned 21 before their green card was approved, could lose their place in line. The new law creates a protected status that freezes their age for petition purposes if they've been waiting for more than 2 years, which will keep thousands of families together who otherwise would have been separated by bureaucratic delays. Now I want to address something that's causing a lot of concern in the green card holder community. There are provisions in this new law related to criminal conduct and deportability, and while the core legal standards haven't changed dramatically, the enforcement mechanisms have been strengthened. Green card holders have always been deportable for certain criminal convictions, particularly aggravated felonies and crimes of moral turpitude. What's new is that USCIS will now receive automated notifications from law enforcement databases when a green card holder is arrested or convicted of any crime. This doesn't mean every arrest leads to deportation, but it does mean USCIS will be aware of it and may initiate review proceedings. If you're a green card holder and you're arrested for anything, even a misdemeanor, you need to consult with an immigration attorney immediately before you talk to the criminal court, because the immigration consequences of certain convictions can be devastating and permanent. The new law also expands the mandatory detention provisions for green card holders who are placed in removal proceedings for criminal reasons. This is a significant hardening of enforcement policy, and it means that if you're facing deportation based on criminal grounds, you may not be eligible for release on bond while your case is pending. This is exactly why maintaining a clean record is absolutely critical for anyone who wants to keep their green card and eventually become a citizen. Let me talk about some positive changes that the new law brings, because it's not all increased scrutiny and new requirements. The law creates a new provisional green card renewal process that will benefit hundreds of thousands of people whose cards have expired or are about to expire. If your green card expires and you filed for renewal, you'll now receive a provisional extension document that's valid for 18 months instead of the previous 12-month extension. This gives you more time and flexibility while USCIS processes your renewal application, which, as we all know, can take much longer than anyone wants. There's also a significant change to green card replacement procedures. If your green card is lost, stolen, or damaged, the new law allows for expedited replacement in emergency situations. If you have an international flight within 14 days, or you need your green card for immediate employment verification, you can now request emergency processing with supporting documentation. USCIS will be setting up dedicated emergency processing windows at select field offices across the country, and approved applications will receive temporary evidence of permanent residence within 72 hours, with the actual replacement card following within 30 days. For green card holders who obtain their status through marriage to a U.S. citizen, there's an important clarification in the new law regarding conditional residence. If you received a 2-year conditional green card because you'd been married less than 2 years when you got your green card, the process for removing conditions has been streamlined. The filing window has been expanded from 90 days before expiration to 6 months before expiration, giving you more time to prepare your application. Additionally, if you're divorced or widowed before you can remove conditions, the new law provides clearer guidance and more flexibility in proving that your marriage was genuine, which previously was a major source of denials. So what do you need to do right now today to make sure you're in compliance with all these new requirements? First, check the expiration date on your green card and mark your calendar for the biometric update requirement, even if your card isn't expiring soon. Remember that biometric updates are now required every 5 years. Second, if you travel internationally for work, family, or any other reason, start keeping detailed travel logs right now. Note every date you leave the United States and every date you return. Keep copies of your boarding passes, passport stamps, and any other evidence of your travel. Third, organize your tax documents, employment records, and residential history. Whether you're planning to apply for citizenship next month, or 5 years from now, you need this documentation, and it's much easier to organize it as you go, rather than trying to reconstruct years of history later. Fourth, if you use or plan to use any public benefits, understand which programs trigger reporting requirements, and keep documentation of the circumstances. Fifth, if you have any interaction with law enforcement, even something minor, consult with an immigration attorney before resolving the case in criminal court. Sixth, register for a USCIS online account if you haven't already. The government is moving more and more services online, and having an account will allow you to file the new travel notifications, check your case status, receive important notices, and update your address. Seventh, if you're eligible for the fast-track citizenship program in a critical shortage occupation, start gathering the documentation. You'll need to prove your continuous employment in that field. This new law represents the most comprehensive reform to the green card system in recent memory. And while some of the changes create new obligations and requirements, many of them also provide new protections and opportunities. The key to successfully navigating these changes is staying informed and staying compliant. That's exactly why U.S. Immigration Alert exists. To give you the information you need when you need it, in a format you can actually understand and use. Before we wrap up, I want to remind you that immigration law is complex, and individual circumstances vary widely. While this video gives you a comprehensive overview of the new law and what it means for green card holders generally, your specific situation may have unique factors that require personalized legal advice. If you're unsure about how these changes affect you specifically, or if you have complicated circumstances involving criminal history, benefit usage, extended time outside the United States, or other issues, please consult with a qualified immigration attorney. Most attorneys offer initial consultations, and the investment in proper legal advice now could save you from devastating consequences later. Thank you so much for watching us Immigration Alert today. If this video helped you understand the new immigration law and what you need to do to stay compliant, please give it a thumbs up and share it with other green card holders in your community who need this information. Subscribe to U.S. Immigration Alert and hit that notification bell so you never miss an update, because immigration law continues to evolve, and we'll be here to break down every important change that affects you and your family. Drop a comment below and let me know what questions you have about the new law or what immigration topics you want us to cover next. Your engagement helps us create content that serves this community better. Remember, knowledge is power, especially when it comes to protecting your immigration status. Stay informed, stay compliant, and stay tuned to U.S. Immigration Alert for all your immigration news and updates. I'll see you in the next.